Everyone, well, Midway Gaming, and happy Halloween! We're doing a Halloween special. Not in the cards, this was not pre-planned, but it just kind of worked out that way, so here we are. Today is an interesting day because we actually got more details surrounding that whole Palworld business. You know how Nintendo is kind of ticked off that Palworld is being Palworld and, you know, kind
Palworld.
of looks like Pokemon, kind of looks like Pokemon if you squint at it a bit, in some regards. Well, we actually have an update on that whole business. Well, we might have covered, I think we actually covered earlier in the episodes, that Nintendo actually filed a patent to kind of copyright the whole monster capturing thing to use in its case against Palworld. Granted, this was retroactively, so they're basically patenting it after Palworld to basically retroactively use it in its defense to make a very complicated story short. Well, the legal court of Japan basically threw out the patent. It has been rejected by the Japanese Patent Office for, in their words, lacking originality. Which is interesting because this means that our world can basically use the basically fact that the Japanese Patent Office refused to give Nintendo the credit of the patent as defense against them in the court case of Power World. So, to say that another way, Nintendo's attempt to get more defense actively gave Power World more defense in the long run. They kind of helped their enemy here.
It didn't
The
work out.
decision cites a yeah. The decision cites a lack of incentive steps, pointing directly to older games such as Arknights, Monster Hunter 4, Craftopia, uh, Patani Collection, I think I pronounced that right, excuse me, and of all things, Pokemon Go itself as examples of prior art. So, yeah, that's interesting. It basically says, hey, you can't have the patent because these things have done it before, including Pokemon Go itself. So Pokemon kind of had its own license used against it here, which seems to be the kind of moral of this story. Pokemon and Nintendo tried to give themselves a defense by getting a patent retroactively, and instead actually gave their defense more defense by basically having their patent thrown out. So that's interesting.
It didn't work out.
Yeah. To kind of go on with this article here that I've been kind of reading from Windows Central, which will be linked down below. Also, another article that has more details on the legal side of things from GamesFry. That's also linked down below. Let me just get where I was looking at. Ah, yes. It reinforces the argument that Power World isn't necessarily copying Nintendo, but rather is inspired by and built upon decades of established game mechanics. And then they provide a actual description here. They provide an image here of the actual patent family tree, which sadly I cannot read for the most part because some of it is written in kanji, and I cannot read kanji, so sorry. But some of it is patent numbers. And it does mention the report from GamesFry, which I believe this image is actually referencing. Yeah, it is here. Image credit from GamesFry, which again, link down below, breaks down the significance of this patent rejection in relation to the Pocketpair case. If you look at the official JPO, so the Japanese Patent Office patent family chart, which is shown in the thing, which is linked here, you can see how interconnected these filings are. The newly rejected 2024 0013879, which is just a patent number, I believe, application descends from Nintendo's 2023 filing JP7505852, which again is just the patent number, which has been granted and is one of the patents cited in Nintendo's lawsuit against Pocketpair, who I believe are the creators of Palworld. Meanwhile, patent 2024 123560 JP7545191, good night. Reading these numbers is causing my eyes to blend together, branches off another granted patent also being used in court. This means that it isn't some irrelevant side filing, it's literally sandwiched between two patents central to the litigation. If the JPO finds that one member of the patent family lacks originality, it raises questions about the others. As GameFry notes, this sibling parent structure makes the 2024 patent number given here rejection patent potentially significant. The same reasoning, lack of my tongue is not working here, excuse me, ladies and gentlemen. Inventive step, obviousness based on prior art could easily apply to the related patents Nintendo is wielding in court. So basically they're calling their own patents into question here by having one of their patents thrown out. The JPO's record shows that a third-party submission was made earlier this year, introducing prior art that led to this rejection. While the JPO doesn't name who made it, the timing aligns with Pocketpair's known strategy and its April 2025 court filing of similar evidence. In fact,
Interesting.
GameFry's earlier coverage revealed that Pocketpair's legal team has already submitted an extensive list of games from Ark and Tomb Raider to Zelda, Timefall 2, and Rune Factory 5, all to demonstrate that Nintendo's claimed mechanics existed long before Palworld. So, to make a bunch of legalese more understandable, they filed a patent in basically a line of patents that are all connected in their legal case. One of those patents was thrown out. However, because if I'm reading this correctly, and again, correct me if I'm wrong, legal people here, Japanese law is not my specialty, obviously. It seems that by having that patent thrown out, all of the other patents in series are kind of being called into question here. Not only that, but it also seems to indicate that because the patent is thrown out and other things have been demonstrated by Pocketpair, which is the people who made Palworld, that there is actually precedent for the mechanics that were piled in the patent, which, if memory serves, are actually monster capturing in a ball, is just relevant in other art forms. So basically, that means that it exists prior to Palworld, therefore you can't copyright it. Which is kind of the oversimplified version of it. Again, legal experts correct me on the more specific details here. And in the actual GameFry article that all of this is citing, it actually kind of goes more into the details of what's going on here. One of the direct impacts of this is that Nintendo now faces, again according to GameFry, Nintendo now faces the choice between abandoning the embedded patent, embattled patent application, of which is the more likely step, trying to persuade the patent examiner based on a modified patent application with amended claims. So basically, their patent claim that was rejected, they have to amend it and then put it back and say, well, what if we did it this way? Will you take it then? Also, when the process at the patent office is over and appeal to a specified court, namely the Intellectual Properties High Court, the IPHC, is possible, the Japanese patent prosecution process has been described as an endless loop. So basically, this might never end. World Intellectual Properties Report. But the fact that the patent examiner is now looking at real-world games as opposed to just patent documents and articles considerably ups the ante for Nintendo. For the avoidance of doubt, even if this Nintendo application fails, there is no direct impact on the Palworld case. However, they say see the next ramifications, and it goes into more wider ramifications of this JPO. Again, more of the legalese in the GameSpy article. But basically, because of the fact that Nintendo, or not Nintendo, because the patent and the case itself is now looking. Excuse me, let me say that again. My tongue is having problems today, ladies and gentlemen. Because the court case is now looking at other games beyond just what the patent is claiming, it does up the ante for Nintendo because at the end of the day, everyone knows that these mechanics have existed far beyond just the Palworld and Nintendo side of things. And that is kind of the part of why that patent fell through, because they're like, well, monster mechanics, and I believe specifically ball capturing was what they were filing for, is strictly a Pokemon thing. But there's cases of it in other places as well, or at least the monster capturing part. So now it's like, well, Nintendo, you can't claim that this is specifically yours because people have been doing it other than you, and you never complained before, so why complain now?
Yes.
So yeah, it is kind of a big thing. And this does, like I say, kind of give Palworld more defense. So if anyone was concerned that this whole legal patent was going to put a nail in Palworld's coffin, it actually did the opposite. It pried one out. So yeah, interesting little ramification that has a lot of ramifications on Nintendo in general. Like I said, they're kind of left with abandoning this patent claim altogether, rewording it, or just appealing and seeing where that gets them. So yeah, interesting little position we're finding in. Call this a follow-up to the Palworld versus Nintendo thing. What do you think, Justin?
Think that like this is like really interesting because like we covered, Nintendo obviously never really complained about this before, and there are numerous amounts of cases of capture mechanics specifically being in games in some form or another in like many ways before. So it's interesting to see that that gets like pointed out by the Japanese case, and that also helps put into question as to why Nintendo was able to get such a patent in the first place on the United States front. if the Japanese front was so quickly, like, and easily going to point out, hey, there's all these examples where this does not add up.
Well, that's the thing when you kind of bring it to the end of the day, right? The Japanese and the US patent offices are very much East versus West patents, and they are
Mm-hmm.
very different cases. So you can have a patent in one office, but not in the other. So technically, you can patent something in the US, but that doesn't mean you'll hold any legal sway in the Japanese division,
No.
which is probably why they were trying to go after the patent on their home soil, which ironically is where they lost the patent. Which, like we mentioned in the show earlier on, is interesting because of how the Japanese patent office works. They're all patents that are kind of labeled in series versus individually. And the way the Japanese law works, if I'm reading this correctly, again, correct me if I'm wrong, legalese individuals, especially those who are familiar with Japanese law, is
Yes.
that, and this is one of the bigger ramifications here, because the patent that was labeled got thrown out, i.e., the capture mechanics, all the other patents in series that are labeled to this also get called into question of their validity. So basically, if you have patent A that you get, and then a few years later you get patent B, and you put that in series with patent A, let's say patent B falls through while you're trying to get it. Well, the Japanese court might look at the patent A and say, hold on a minute. If patent A is related to patent B, and patent B fell through, I wonder if patent A is also kind of bull and we didn't realize it at the time. That feels like what's going on here. So it definitely feels like Nintendo shot themselves in the foot here.
Yeah. They're kind of pushing for too many patents and it's not going over well.
Interestingly enough, one of the wider ramifications mentioned here is pretty much what we just kind of covered. An issue facing a central member of a patent family is also indicative of validity problems facing other members. Members? I think that's a mistype, but anyways. But again, it's as we said, right? If you have something in a family of patents and a new member of the family that tries to get initiated falls through, the rest of the patent family's validity is called into question, whether you have those patents already or not. So, like I said, not a good look for Nintendo right now, especially on their home soil. If this were the US, they might be able to do something about it because it's technically not home soil, but the fact that they're losing this on their own home soil is kind of embarrassing.
It's not going to go over well.
Interestingly enough, however, it does say that a JPO, the Japanese Patent Office decision, much less. Let me say that again. A JPO decision, much less a non final one, is non binding. On proceeding, Judge Mut. Forgive me if I am. Who is
Here.
handling the Nintendo
Try that again. Try that again.
I've never seen him have this kind of thing before. Matayuki Nakashima, I believe.
There you go.
Anyways, who is handling the Nintendo v Pocketpair case? I have to work on my tongue exercises again. But judges are legally trained and tend to have respect for the determinations made by examiners who are technically trained. Pocketpair might try to point out the Tokyo District Court to relevant departments in the JPO in the US. That would be called a request for judicial notice and can influence decisions. We assume that there will not be a decision of any kind in the infringement case before next year. The proceedings have been delayed, presumably due to what the next bullet points out, which is the Nintendo's third patent in suit is also in trouble. They felt forced to seek a modification in the middle of litigation. So basically, when their patent fell through, it made trouble, so then I have to modify it, which is going to basically take time in the litigation process. So basically what this pretty much is that they can say, the US said it's good, so...
This is okay now, right?
So technically the JPO's decision is... And technically this isn't a final decision from the JPO, is non-binding. So... Just because the Japanese ones fell through, they could always go to the US and say, well, the US patent office said it was good, so...
It's okay now, right?
Actually, no. Correction, I'm reading that wrong. It's been a long night.
It's been a long day.
They might point it out and say, well, it might work. Anyways, Again, the legalese is a bit above me, so forgive me if I'm misquoting, and Lord knows I probably am in a lot of this. I'm probably butchering this. But the kind of moral of the story here is that the patent they tried to file on their home owned soil of Japan fell through, and now that's kind of called into question all the other patents they have in the family of patents that this was linked to. And at the end of the day, this is proving very problematic for, again, the Palworld versus Nintendo case because Nintendo was hoping to use this against Palworld, and now they can't. If anything, they've just given Pocketpair, i.e., the developers of Palworld, more evidence. Pocketpair? Pocketpair. I think I've been saying Pocketpair this whole episode. Like I said, my enunciation right now has completely gone down the tube. I'm gonna have to work on my tongue exercise, ladies and gentlemen. But anyways, that's kind of where we are with this episode. That would give you an update on the whole Pocketpair versus Nintendo Pocketpair. There I go, doing it again. Pocketpair versus Nintendo case, and just kind of seeing where this is. Like I said, kind of interesting to see the Japan. Oh god, my enunciation
Jeez.
is dead. It's kind of interesting to see that Nintendo lost their own patent on their own home soil. And it'll be interesting to see where this kind of plays out in the long term for the patent office, like I said. Like the article points out, this is technically a non binding decision. So you never know. They might just mess with their patent a bit and resubmit it and see if that holds any water, but we'll see. Anyways, that's kind of the show. Happy Halloween, ladies and gentlemen. Thought we'd get this out to you. I promise my enunciation will be better next episode. I feel like understanding me this episode has been an absolute nightmare, but it'll get better. I promise you. Anyways, have a good week, have a good night, and happy Halloween, everybody.
Take it easy.